By Isaac Stanley Becker. Isaac Stanley Becker, reporter based in the UK. Email bio follow September 27 at 6:58 a.m. The Senate lacks guidelines or rules to assess the testimony that is expected today from Supreme Court nominee Brett M. Kavanaugh and one of the women who has accused him of sexual assault, Christine Blasey Ford. It's largely about politics. But there are standards of proof inherited from the justice system: preponderance of the evidence, clear and convincing evidence, or beyond a reasonable doubt. And a debate is unfolded, alongside the contest over the allegations themselves, about the suitability of these principles, and about who has the burden to prove what. In a hyperpartisan climate, views tend to split according to pre-existing positions on the nominee. There are not clear rules on the burden of proof in a congressional investigation, said David J. Levis, a Washington-based attorney with O'Melveny and Myers who has significant experience with Senate inquiries. Instead, he said, lawmakers tend to rely on a gut standard based on their own barometers. If I had to put a name to it, maybe the standard is what offends the sensibilities. It's a loose standard of behavior for what doesn't seem right, and they're making a judgment that the public will agree with them. Lawmakers no doubt want clarity about what may have unfolded between the witnesses, Levis said, but the greater purpose of this process, I think, is still to evaluate his fitness and suitability for confirmation to the Supreme Court, which is ultimately a different question than if he did commit a crime 36 years ago. I make this distinction because I doubt very much will come out of Thursday with sufficient clarity to meet any of the standards of proof for civil or criminal litigation, Levis added. If that's the goal Chairman Charles E. Grassley sets forth, that will be difficult. The distinction goes to the heart of what separates starkly different schools of thought about how Thursday's hearing should be framed. One way of understanding the hearing is similar to a proceeding in the criminal justice system, said Ilya Samin, a law professor at George Mason University. The other is that it's like a job interview. The difference matters because a criminal proceeding would place the burden of proof on the accuser, maybe even having to prove her claims beyond a reasonable doubt, Samin said, while a job interview would obligate Kavanaugh to prove himself unsullied. A number of Democrats have embraced the idea that the onus is on Kavanaugh, as he is up for a promotion. Senator Christopher A. Coons of Delaware told MSNBC this week that it is Judge Kavanaugh who is seeking a lifetime appointment to the Supreme Court, and who I think now bears the burden of disproving these allegations. The statement led conservative observers to complain of a kangaroo court in which the presumption of innocence is turned on its head. But the maxim of innocent until proven guilty is embedded in the American legal tradition as a standard designed to protect those who have been charged with a crime. This is not about whether or not he should be convicted, Senator Kirsten Gillibrand, DN. Y, said Wednesday on the Senate floor. This is about whether he has the privilege to serve on the highest court of the land for a lifetime. This is not a court of law. This is a job interview. Just because the hearing is not a criminal trial does not make it a simple job interview, wrote Adam J. White, a research fellow at the Hoover Institution and director of the Center for the Study of the Administrative State at George Mason University's Antonin Scalia Law School, in the Weekly Standard. Senators, in exercising the obligation of providing advice and consent, also are deciding what sort of evidence is credible and what sort of claims should be grounds for blocking a nomination. He wrote that allowing a belated, evidence-free accusation to stop a Supreme Court nomination will immediately create incentives that undermine the Senate's confirmation process in future nominations. It's not clear why either party alone should bear the burden of proof, said Robert McCand, a professor of law and psychology at Stanford. Placing the burden on witnesses might discourage their participation, he said, while placing it on nominees risks dissuading qualified individuals from going into public service. Situations in which witnesses share the burden of proof, he added, create an implicit preponderance of the evidence standard, common in civil cases, where each party duels to present more credible and convincing material than the other. The appearance of credibility is the most important factor in any of these situations, said Levis, the attorney who has been involved in congressional investigations on topics ranging from bankruptcy to food safety. And establishing credibility often starts long before a hearing or trial. That became clear this week as Kavanaugh, currently a judge on the U.S. Court of Appeals for the D.C. Circuit, sat for a Fox News interview, the first time a Supreme Court nominee has done so, in which he said, "The truth is I've never sexually assaulted anyone, in high school or otherwise." The emphasis on issues of individual character was also apparent in his description of his younger years as dominated by school and service, at odds with the recollections of others. The issue of personal credibility was also paramount in opening statements released Wednesday by both witnesses. Kavanaugh will speak Thursday of grotesque and obvious character assassination, while Ford will offer some insight into her personal history and cite her civic duty to tell you what happened to me while Brett Kavanaugh and I were in high school. She claims that Kavanaugh, when he was 17 and she was 15, groped her, grinded against her, grasped to remove her clothes, and placed his hand over her mouth when she attempted to scream. The statements do not have much in common, yet they both disclaim political motives. Kavanaugh, as I told this committee the last time I appeared before you, a federal judge must be independent, not swayed by public or political pressure. Ford, I have been accused of acting out of partisan political motives. Those who say that do not know me. I am a fiercely independent person, and I am no one's pawn. That may be true for the witnesses, but politics will dictate how the public weighs their claims, predicted Salmon of George Mason's Antonin Scalia Law School. In the schism between the criminal justice analogy and the job interview analogy, the one you embrace seems highly correlated with your political views, said Salmon, a libertarian whose expertise combines constitutional law and popular political participation. The consequences of this are that very few people, I think, are trying to weigh evidence objectively. Unless a definite piece of evidence emerges, a large portion of the country will believe the conclusion of the process, whatever the conclusion is, to be illegitimate, he said.